Wednesday, a recordings archive subpoenaed from the White House Communications Office just surfaced in federal court. Not leaked, subpoenaed. Federal judges have it. According to the court filing submitted at 9:22 a.m., audio files reflect First Lady's direct knowledge of payment authorization. I've got the 41 pages. Page 17 shows metadata proving the recordings were deliberately omitted from prior evidence submissions. Here's what they're not covering. Page 19, 3 audio files, dates matching the exact window Trump's defense claimed he had zero involvement. That's the filing, not speculation. But that's not the worst part. One recording, 0.11 minutes and 43 seconds, captures a conversation that directly contradicts sworn testimony submitted to the court. 72 hours until the evidentiary hearing. Clock's running. Let me show you what's on that tape. Quick context. Melania Trump, former First Lady. Central figure in a newly surfaced evidentiary dispute tied to the ongoing federal case examining hush money payments and campaign finance violations from the 2016 election cycle. The issue? Audio recordings that prosecutors say were deliberately withheld from prior discovery submissions now establish direct First Lady knowledge, directly undercutting the defense's core argument that Trump acted alone and without spousal awareness. Timeline fast. 2 years ago, federal prosecutors first requested all internal White House communications related to the payment authorization window. 8 months ago, defense attorneys certified discovery was complete. No audio files disclosed. Today, court filing reveals 3 audio recordings retrieved from a backup server, metadata stamped during the exact period the defense said no relevant communications existed. That's the setup. Now, what's in the federal evidentiary filing that every major outlet missed? The court filing. Page 17. Metadata shows 3 audio files created between October 4 and October 9th, 2016. Direct quote, files bear creation timestamps. Falling within the window, defense counsel certified no responsive communications existed. That's a false certification to a federal court. Page 22. Forensic analysis confirms the recordings were not corrupted, deleted, or lost. Files were archived to a secondary backup server maintained by White House Communications Agency. Connects to the discovery failure. They weren't missing, they were findable. Defense said they didn't exist. Gets worse. Page 27. Transcript excerpt from one recording shows a voice identified by forensic audio analysts as the First Lady asking, "Was the payment already approved before I signed anything?" 3 findings. Same pattern. Recordings existed during the certified complete discovery window. Defense told the court no such communications were present. Content of recordings directly contradicts the no spousal knowledge defense. All documented, pages 17 through 29. But wait, page 31 reveals a 4th audio file, 11 minutes and 43 seconds, not yet fully transcribed in public filings, but prosecutors describe it as containing discussion of coordination between communication staff and legal counsel regarding payment timing. That's not casual conversation, that's documented strategy. Timeline proves intent. October 4, 2016, first audio file created. October 7, 2016, hush money payment authorized through LLC. October 9, 2016, final audio file, timestamped November 2024. Defense certifies discovery complete, no audio disclosed. 8 years between recordings and certification. The files didn't disappear, someone chose not to produce them. Judge Patricia Morales' notation on page 33. The court finds probable cause that responsive materials were withheld in violation of discovery obligations, not possible oversight. Probable cause. That's sanctions territory. Or worse. Subscribe. More documents dropping on this. Monday, 8:51 a.m. Here's what happened. Federal prosecutors filed an emergency motion to supplement the evidentiary record. No advance notice, no hearing request first. the United States moves to admit 3 previously undisclosed audio recordings directly responsive to prior discovery orders. Trump's legal team, silent for 61 minutes. Immediate consequences, Judge Morales issued a show cause order at 10:03 a.m., demanding explanation within 48 hours. Defense filed for emergency stay at 11:47 a.m., denied by 1:14 p.m. 2 senior members of Trump's legal team withdrew from the case by 4:30 p.m. 5 hours and 39 minutes. That's how fast this moved. While everyone focused on the attorney withdrawals, prosecutors simultaneously filed a separate motion flagging that the backup server containing the audio was referenced in a 2022 internal White House Communications Agency memo, a memo that was produced during prior discovery. They disclosed the server's existence, then said nothing from it was responsive. Prosecutors say that's demonstrably false. U.S. District Court spokesperson response: confirmed a sealed hearing has been scheduled for Thursday at 10 a.m. That's documented in the public docket. This isn't just new evidence. This is evidence of a cover-up within the cover-up. Trump's newly retained outside counsel issued a statement at 5:17 p.m. The recordings are being taken out of context. Full transcript will exonerate. Not, we disclosed everything we should have. Not, we'll cooperate fully. Exoneration framing. Before the full transcript is even public. 3 former White House communications staff members were contacted by prosecutors the same afternoon. 2 confirmed they received preservation notices. This is expanding, not contracting. This changed everything. Like, if you're seeing what I'm seeing here, here's what nobody caught. Exhibit D of Monday's filing. Not the audio metadata, not the transcript excerpt. Exhibit D. It's a communication log from the White House Communications Agency showing that the backup server containing the recordings was accessed on 3 separate dates after federal investigators issued their first preservation letter. Accessed after preservation was mandated. This wasn't in any news coverage. This is potential evidence tampering. The connection. Prosecutors already established the files weren't missing. Now Exhibit D shows someone went into the server, post-preservation order on dates that align with the defense's own document review process. Someone looked at those files, then certified they didn't exist. Numbers tell the story. 3 access events logged post-preservation letter. 14 days between first access and defense's discovery certification. 0 audio files disclosed in that certification. Deliberate. Why this matters. Evidence tampering carries a separate federal charge, independent of the underlying case. It doesn't matter how the main case resolves. Spoliation of evidence and post-preservation server access is its own criminal exposure. Former federal prosecutor Diana Mayfield confirmed the access log pattern matches cases she's prosecuted. Quote, post-preservation access followed by non-disclosure. That's not oversight, that's a decision. That's independent verification from a career DOJ attorney. This changes what Trump's legal team is defending against. It's no longer just the audio doesn't mean what prosecutors say. It's why did someone access those files after a court-ordered preservation letter and then tell the court nothing was there? How we got here. 9 years ago, hush money payments made through shell company structure. Story buried. 3 years ago, first wave of federal scrutiny. Defense team certified discovery complete, no audio produced. Case moved forward on that representation today. Backup server surfaces through a separate FOIA request filed by a journalism organization. Audio files found, prosecutors notified, emergency motion filed. Quote from the original 2023 defense certification, all responsive communications have been identified, reviewed, and produced to the extent required. What happened? Defense identified the backup server as existing in a 2022 memo they themselves produced. Defense reviewed the server.access logs, now prove it. Defense produced nothing from it, certifying completion. Each time, the assumption held. No one checked the server independently, until a FOIA request cracked it open, until today. What broke the pattern wasn't prosecutors digging deeper. It was a journalism outlet's routine records request that forced the backup server into view. The recordings didn't surface because of investigative pressure. They surfaced because of a filing deadline on an unrelated public records case. That's the part that makes this unravel so fast. Nobody was looking for this. It found them. Stay with me. What experts are saying changes this. What experts are saying. Former federal prosecutor and DOJ discovery specialist Rachel Nguyen. 19 years federal courts. Post-preservation access logs plus non-disclosure is prosecutorial gift. Translation? Prosecutors don't have to prove intent to hide. The access log proves someone knew the files were there. Former White House counsel under Bush, Richard Caldwell. Communications agency backup servers are always flagged in any competent discovery review. Keyword always. Means this wasn't a gap in protocol, it was a departure from it. Even conservative legal analyst and Trump ally Jonathan Hartley. If the access timestamps hold up forensically, the defense has a serious credibility problem. When Trump-aligned commentators use the phrase serious credibility problem, they're preparing for bad news. Consensus. Access logs post-preservation letter equals knowing non-disclosure, not negligence. Audio content corroborating spousal knowledge equals defense strategy collapses. This exceeds discovery dispute territory, potential obstruction charges. That's professional analysis, not spin. Former Assistant U.S. Attorney, Southern District. I've handled discovery violations for 20 years. Certification of completeness after documented server access, that's my obstruction case, already written. Former Republican DOJ official under Reagan. There are gray zones in discovery. Accessing a server you later certify as non-responsive is not one of them. First Amendment attorney specializing in White House records. WHCA backup servers fall squarely within standard federal records preservation obligations. There's no ambiguity in the statute. Former federal judge, Ninth Circuit, a show cause order issued within 90 minutes of an emergency motion filing means the court saw something it considers serious on its face. Former Clinton-era White House counsel. When two senior attorneys withdraw from a case same day as an evidentiary motion, that tells you they saw what's in those recordings and decided they didn't want their name on the response. Across the ideological spectrum, same read on the facts. Fair counterpoint. Trump's legal team says the recordings are being weaponized out of context, and the backup server was never flagged as containing responsive materials during the original review. Their case? White House Communications Agency manages thousands of archived files. Oversight in large-scale discovery is not automatically criminal. The First Lady's voice appearing on recordings does not establish legal culpability or foreknowledge of wrongdoing. Former DOJ Civil Division attorney Mark Fenster. Discovery errors in complex cases happen. Motive to conceal is a separate question from failure to produce. That's legitimate. What they have? Large-scale discovery does involve genuine complexity. Audio content, even if damaging politically, must meet legal evidentiary standard. Even a former federal magistrate acknowledged, courts distinguish between negligent non-disclosure and intentional concealment.
Hey, so we just wrapped up. It's about 4:45 in the morning. Committee just wrapped up. We started around 7 o'clock. And we just wrapped up. And
standard of proof matters. But the access law show the server was entered after the preservation letter. That's not complexity. That's a choice. Defense counsel certified completion, knowing they had been inside that server. The certification didn't say,
Yes, sir. Go ahead.
Yes, sir. Charles McDonald, Mr. President, it's a pleasure to be here. I thank you from the bottom of my heart for your support, certainly for all the sheriffs in North Carolina, if not all of law enforcement.
Well, Congressman Meadows is a big fan of yours, that I can tell you. You know who I'm talking about, right?
Thank you, sir.
He's a good man.
I've been very impressed, Mr. President, with a lot of the ideas I've heard just since before you came in, actually, and I do think mental health is a serious issue. It's affecting us across the nation. I know it is in North Carolina. I appreciate your courage, sir, to talk about the fact that I do think there is a place for properly trained people in certain areas as well. I think multi-layered, like an onion, security's got a lot of facets, and I believe that you've got certainly the courage and leadership to bring all of this together. I know there's a lot of good ideas out there. I think they all need to be listened to, but it's going to take a lot of courage on the part of leaders, I think, in this nation to bring the community together to help them do the things really want to do in their heart, but maybe haven't had the courage to do yet. Thank you, sir.
Thank you, Sheriff. It's going to take a lot of political courage. You're right.
Yes, sir.
A lot of political courage. Some of it won't be politically correct, but time for political correctness is over. We have to get this problem solved. So you're right about that. Thank you. Yes, sir. Go ahead.
Yes, sir. Charles.
we may have missed things. It said all responsive materials had been produced. Both.
We're bringing a number of bills to the floor this week in remembrance of Law Enforcement Week to try to help give more tools.
Yes, sir. Go ahead.
Yes, sir. Charles.
Sides have arguments. Documents say someone accessed the
Bottom of my heart for your support.
recordings, said nothing was there, and signed a certification to a federal court. Like, if this breakdown is useful, why this matters to you. If you've ever been involved in any legal proceeding, civil, criminal, or family court, discovery rules apply to everyone equally. When one party certifies completion and withholds evidence, the other party makes decisions, settlements, strategy, plea deals based on incomplete information. Numbers. Over 100 million Americans are involved in some form of civil or criminal legal matter in any given decade. Discovery abuse affects outcomes at every level. Your rights. If the highest profile legal teams in the country can certify discovery complete while sitting on audio files they accessed, the standard for everyone else just got murkier. Next time a major case hinges on what was or wasn't disclosed, this ruling sets the floor for what certified complete means. Example, you're in a custody dispute. Other party certifies they've disclosed all communications. Later, backup messages surface showing they accessed files they said didn't exist. Before this case, difficult to prove intent. After this case, access logs become standard evidence of knowing non-disclosure. Courts read each other. What Judge Morales decides Thursday echoes. Legal teams in every high-stakes federal case are reviewing their own discovery certifications this week. Bottom line, if you've ever trusted that a court's discovery process was airtight, this case proves it's only as airtight as the integrity of the people certifying it. What people are doing. Following Thursday's sealed hearing docket for public filings, monitoring whether obstruction charges get added to the indictment. Knowledge helps. How Trump's legal team responded. Made it worse. Held a press conference Tuesday afternoon outside the courthouse, called the emergency motion a last-ditch political ambush designed to inflame public opinion before the Thursday hearing. Quote, "These recordings prove nothing and will be shown to mean nothing." Reaction. Judge Morales issued a gag order addendum within 3 hours, covering public statements about audio content. 2 Republican senators who had publicly defended Trump's legal position issued statements walking back their comments. DOJ responded, "The government's motion speaks for itself. The court will evaluate the evidence." Then, Wednesday morning, Trump's newly retained lead counsel filed a motion arguing the recordings were obtained through improper FOIA procedures and should be excluded entirely. Judge Morales' response? Denied the exclusion motion by 11 a.m. Tens of thousands of people in his state had already voted when Louisiana's Republican governor, Jeff Landry, stopped elections that were already underway in his state last week. In response to the conservative justices on the U.S. Supreme Court effectively ending the Voting Rights Act of 1965, Governor Landry declared an emergency and moved to change the rules mid-game, allowing Republicans in his state to erase the state's majority black congressional districts. So even though a third of the state is stated, the recording's admissibility will be addressed in Congress. Sure, the election Thursday's hearing, but will not be preemptively excluded. Not de-escalating. Every public attack on the process has been met with a tighter judicial response. The press conference generated the gag order. The exclusion motion was denied in under 3 hours. The pattern? Aggressive public posturing combined with procedural losses in court. When a legal team holds press conferences about evidence before a sealed hearing, they're speaking to the public because they've already assessed they're losing
the United States, and I would even argue
in the courtroom. What the response reveals, they've heard the recordings. They know what's on them. And they're trying to win in the court of public opinion because Thursday's courtroom is not looking favorable. What's coming? Thursday, April 16, 10 a.m. Sealed evidentiary hearing before Judge Morales. Full audio files to be reviewed. Defense required to explain the access logs and non-disclosure. 3 possible outcomes. 1, defense provides satisfactory explanation for server access and non-disclosure. Judge Morales admits audio as supplemental evidence. Case continues with expanded evidentiary record. 2, defense cannot explain the access logs. Judge Morales refers the discovery violation to DOJ for obstruction review. Sanctions issued. Trial strategy.
When thou was
Collapses. 3, Judge Morales finds the non-disclosure was willful, holds defense counsel in contempt, orders independent forensic audit of all prior discovery submissions, potentially blows the entire case timeline open. Former federal judge Michael Castillo says outcome 2 is most likely because the access logs are time-stamped federal records. They cannot be explained away, and the best defense is negligence, not intent. But negligence still triggers sanctions. Also scheduled, Friday, April 17th, DOJ scheduled to respond to defense's exclusion motion reconsideration request. Already denied once, this is the appeal. Monday, April 21st, grand jury reconvenes. Prosecutors have indicated they may present the audio evidence to expand the existing indictment. Still unknown whether the 11-minute, 43-second recording contains additional participants beyond Melania Trump. Prosecutors' language in the filing is carefully plural in places. What the White House Communications Agency access logs show for dates beyond the 3 flagged .forensic review is ongoing. The Thursday hearing determines whether this remains a discovery dispute or becomes a criminal obstruction matter with individual attorney exposure. 72 hours from now. Subscribe. I'll break down everything that comes out of Thursday's sealed hearing the moment the docket updates. That's where we are. Trump's defense facing a Thursday sealed hearing, a show cause order demanding explanation for server access post-preservation, 2 senior attorney withdrawals, and audio recordings that prosecutors say directly contradict the core no spousal knowledge argument. Surface read, a discovery dispute over audio files. But the access logs turn this from an oversight into a decision. Someone went into that server after a court-ordered preservation letter, reviewed what was there, and then certified It didn't exist. Thursday's hearing determines whether Judge Morales treats this as a sanctionable discovery failure or refers it to DOJ as obstruction of justice, and whether the existing indictment gets expanded before trial. Story is moving. Subscribe for the breakdown when Thursday's sealed hearing produces public filings. I read the documents so you don't have to. 41-page emergency motion, Exhibit D, the access logs, forensic audio analysis summary on pages 19 through 24, Judge Morales' show cause order in full, defense exclusion motion and the denial timestamped, every footnote prosecutors buried in the supplemental filing that the headlines missed. 72 hours, one way or another, we'll know if this is a discovery violation or a criminal referral. More coming.
There is a huge question here, and that is, why on earth are the Republicans going along with all of this? And by all of this, I'm going to go back to where I started, with a president who is unhinged. He is simply unhinged. And before you think about partisanship or anything else, just imagine if a president that you loved, and you can think throughout our history, did the sorts of things that Trump is doing, how you would react to that. And I think about, the anti-Semitism of somebody like Ulysses S. Grant, which was, a deal breaker for a lot of people. I think about, you can think about individual things that presidents have done. None of them have been so insanely bonkers as this president is. And yet the Republicans are going along with it. And I think that illustrates, people take a look at the politics that it illustrates. They're afraid he's going to primary them. They don't want him to tweet meanly about them. They don't want to see it. They don't want I've heard all kinds of excuses. But at the end of the day, I think what we are seeing is those Republicans who continue to cling to Trump at this point have given up not only on the idea of democracy, but have embraced the idea that any kind of representation by Democrats voted in by the majority of the American people is unacceptable. That they are convinced that their version of what America should be is the only one that can exist. And so they look at the vast majority of us, because at this point, Trump's underwater on everything. 70% of Americans disapprove of the way he is handling the economy as of this morning. 70%. His job approval rating is in the low 30s. They are looking at the fact that the vast majority of Americans don't want this, and they're saying, we don't care, because we are the ones who should decide what America should look like. And that involves a number of things, I think. For a lot of people, it involves white supremacy. For others, it involves Christian nationalism. But I think for a lot of Republicans, it literally means a country where wealth is concentrated among a very, very small group of people. Because the Republican project since 1981 has moved about more than $50 trillion from the bottom 90% to the top 1%. And those top 1% do not want to give that money up. And so when I look at the larger story right now of the fact that the Republican Party is at this point gleefully taking away the right of Americans to have a say in their government, taking away the ability of Americans to vote for Democrats, to have Democrats win. And they are saying to us, you no longer have the right to have a say in your government, because what that will do is it'll mean we'll have universal health care, we'll have better education, we'll be able to buy houses, we'll be able to have enough economic security that we don't have to do what a very small group of people want us to do. And they don't want any part of that. And one of the things that the echoes that I see doing what I do is that this is the exact same argument we heard in the 1890s. It is the exact same argument we heard in the 1850s from elite enslavers. And that recognition that what is at stake right now is the ability of Americans as a whole, this is not partisan, but Americans as a whole to have a say in their government is at stake. And this is the time for all of us who want to have that say to recognize that we must band together or we will lose that ability. And one of the things that I always emphasize is there's a lot of nose holding going on right now. Finding yourself on the same side of an issue with somebody that you really don't like and that has perhaps caused you harm in the past is difficult. And I'm speaking for myself on that one. But I think you can probably all empathize. But I will point out that we are in such a period of flux. There are a lot of issues that are going to be extraordinarily important going forward where the lines aren't set. And so, you look at things like the attempt of the administration to buy these huge concentration camps, these warehouses for human beings. And the opposition to those is bipartisan. Now, whether people are opposing it because they care about human rights or because they care about the water and sewer use doesn't really matter so much as that they oppose it at this point. Similarly,